I will tell you that there are attorneys in this country who they say everyone needs to have a living trust. I think they're very appropriate in some cases, and I think in some cases it makes no sense. Ownership and beneficiary designation will override a will. Because a lot of people say, well, I don't need that because I have it in my will. Well, if you have a beneficiary designation or ownership, that happens before the will ever comes into play. She looked at me, she said, so basically you just saved me $20,000 in tax. And I said, potentially. And she said, well, thank you very much. We'll do it your way.
Hello and welcome to another edition of the Financial Puzzle Playbook with your host, Jim Sumpter. I'm RJ Malik, producer of this podcast. And Jim, looks like it's going to be you and I on this podcast.
It's going to be us. We're going to have a lot of fun with today, though.
Okay.
because estate planning is fun, right?
It is, but you know what? It's necessary.
It is necessary. It is necessary.
And what you're going to talk about, I'm dealing with it with my mom.
You're personally dealing with your mom.
Yeah.
Yeah.
Why don't you just jump right into it?
So let's jump into this, RJ. So this is a question that I get, I would like to say, once a month, but it's probably like once a week. And the question is, should I be on my mom's checking account?
Right.
Should I be a signer on, dad's checking account? Something like that. And there's always a follow-up series of questions to really, truly answer that question. So what we're going to talk about today, we always talk about the financial puzzle. Well, I'm going to jump to the end, and this is part of the estate side, okay?
Okay.
So this is, mom, dad still alive, mom, dad, they have bills that come in, they have things that are necessary. And the kids or one of the kids kind of start stepping in and helping mom and dad. What I see so many times, and I literally was sitting with a client last week, and now she's an only child. Okay. So you would think, okay, well, she should be able to be on mom and dad's account. But we're going to talk about some reasons why that may not be the best idea. And then we'll talk about some reasons why it might not be a bad idea. And so, I know you're in a situation with your mom, but you're not an only child, if I remember correctly.
I've got a sister and two brothers.
Okay, sister and two brothers. So I always ask, if mom's going to put one on the account, I always ask them, do you like one more than the other? Or do you like one? Is one of them your favorite? And I usually get a chuckle, just like you're doing.
Yeah.
And then what happens is they're like, well, not every day, but some days maybe. But why do you ask? So here's what happens. Okay. So in your situation, there's four of you. Okay. If one of you are on the checking account, what mom just did is gifted basically one half of her checking account to the other. And now they have ownership in that account.
Right.
If you're going to do that, you really need to have all four on the account. Because then what happens is mom passes away and now all four take an equal percentage in ownership. If it's just one, then what happens is mom has now given money to just the one child. And so what happens is the other three really kind of got disinherited. So these are some of the questions we go through. So if I'm looking at the reasons why do families do this? It's a convenience. It's a convenience in bill paying. Okay, that's the first reason. Sometimes there's a health reason or a cognitive decline or something like that they want to make sure that bills get paid. And then the third reason I hear is, well, we want to avoid probate. And so let's take one step back and say, anything that transfers by ownership or beneficiary is going to avoid probate. Anything that is sitting in a living trust is going to avoid probate. Now, I will tell you that there are attorneys in this country who they say everyone needs to have a living trust. I think they're very appropriate in some cases, and I think in some cases it makes no sense. So it's a case by case situation. And I think you always want to make sure that you're talking to a professional that knows your entire picture as to if you should or should not put something in trust. When it comes to ownership, it's also important that we look at how do you own it. So we see the initials JTWROS a lot of times on something. That means you own it joint tenants with right of survivorship. What that means is if you and mom own her account, joint tenants with right of survivorship, then she passes away and then you own the account. Or let's flip it around. You pass away. Now it goes back to mom.
Right.
The other way we see it sometimes is what's called TIC, tenants in common. Tenants in common means that you own your half outright and she owns her half outright. So even though it's owned jointly, it does not automatically transfer at death by ownership. It will then go through their estate documents, their half will. And so these are all things that, these are follow-up questions to, should I be on mom's checking account? So let's talk about some advantages. So an advantage to being on the account is, yes, you have access to bills, you have access to money in case of an emergency, you have access to be able to see the account, to view the account online in many cases because you're an owner, okay? It does pass by probate if it's joint tenants with right of survivorship, which most are, but it's really, really important to make sure. And frankly, it's easier because mom has someone else or a couple of people that are sort of looking over. Okay. Let's talk about some disadvantages. And this is where I was talking to my client last week. A couple of these. Number one is, so RJ, I'm going to pick on you for a minute. Okay. Let's say that you are on your mom's checking account. Okay.
Okay.
And something happens to you that you get sued. Well, guess what? Mom's money is now tied up in your lawsuit.
Got it.
Because you had ownership in that money. And you don't live in a community property state. And so, that's a different set of circumstances. And all of that also goes by state law. And if I remember correctly, your mom lives in Florida. You're in New Jersey.
That is correct.
So whose state law trumps who? Well, a good attorney is going to argue that it's you. A good attorney is going to argue that it's her. My point is, it's not always the same.
Right.
And you have 3 siblings. So let's say that all 4 of you are on the account. Well, now all 4 of you are exposed, and mom's money is exposed to all 4 of you. And it's not just a lawsuit. It could be creditor. It could be a divorce situation. I heard a situation one time where there happened to be 4 siblings were on mom's house. Okay. Mom passes away. They wanted to sell the house. The problem was one of the siblings had an IRS lien.
Ooh.
Not on mom's house, but on their other property. Okay.
Okay.
With an IRS lien, that doesn't go by property, that goes by person. So any property that person owns will follow them in that IRS lien. So mom's house, which got tied up with her 3 siblings in this case, now got tied up in this IRS lien. And guess what? All 4 of them lost out because the IRS trumps everybody, and they got their money back because of mom's house. So here's the situation. We don't always know everything that our siblings are doing. And these are risks that are out there. So is that a disadvantage? Absolutely.
What we're running into is my mom, she can't handle her accounts now.
Mm-hmm.
We took her car away because she hit a parked car.
Okay. That's a good reason.
So at this point, she's fine by herself at this point, although we're having conversations amongst ourselves about maybe having someone come in on a regular basis to check in on her.
Hmm.
But as far as paying bills, we have to do that.
Right. Right.
But the thing we do is to protect ourselves. We keep her account just about where she needs every month to pay her bills,
Okay.
because she's pretty well fixed. So she has another account that she gets 3% interest.
It's like a high yield savings or something like that. Yeah. Yeah.
Yeah.
Yeah.
So
Yeah.
that's separate from her bank account.
Hmm. Is that other account just in her name?
Yes.
Okay.
So
okay.
then when she passes, it's then goes to the four of us.
Okay, so we're going to talk about that situation in a second with TOD, so transfer on death or payable on death.
Okay.
But let me ask you this question. Do one of you have power of attorney for your mom?
My sister and myself have power of attorney.
Okay. Are y'all joint power or individually?
Individually.
Individually. Okay. So what you've done is exactly where I was headed, that is a solution, is to make sure that you have power of attorney on the account, because when you have what's called durable power of attorney, and and powers of attorney are written based on the state that that the person lives in when it is enacted, essentially. And so based on Florida law, okay, there's a series of things that you can do, and there may be some things that you cannot do based on what your mom chose when she created the power of attorney. That does bring up a point. Let's say that your mom moved from Florida back to New Jersey for whatever reason. Okay. You would want to revisit her power of attorney to make sure that everything was still valid in New Jersey as it was written in Florida. It very much may be.
Okay.
But you just want to make sure. Okay.
Yeah.
So if you change states, and this is for everyone out there, if you ever change states, or if you have what I call a life event is a death, a birth, a move, or an incapacity, always, always, always make sure that you are revisiting these particular items. Okay.
Got it. Mm-hmm.
Okay. RJ, you mentioned something a second ago that when your mom passes, then the money would move to the four of you. Okay. So what you have is what's called a transfer on death, or some banks will call it a payable on death. It's the same thing. It depends on the banking rules and the law for the state that it's in. And what that is basically a beneficiary designation. Okay. And that gets into that your mom's account, that high yield savings account that you discussed, will not go through the probate portion. It will not go through her estate. It will transfer to the four of you at death. Okay. It's just like a beneficiary designation. So that is a way to handle the what happens if, or the inevitable at some point in time. And then the power of attorney handles while she's alive and breathing. Okay. And so there are two very different scenarios, but two very important scenarios, and something that a planner like myself, an estate attorney, things like that will always be educated on as to what you want to do.
Yeah.
The other thing is, it's very important to understand that ownership and beneficiary designation will override a will. Because a lot of people say, well, I don't need that because I have it in my will. Well, if you have a beneficiary designation or ownership, that happens before the will ever comes into play. And a lot of times the will never has to come into play because everything transfers either by ownership or beneficiary designation, or if you're married, maybe by what's called marital share. So it could be that your will never even gets probated. So it really doesn't matter what was in it, because it never went through the process because everything transferred outside of the will. Okay. So that's something that we're always reviewing. What all of these things do is it will also reduce disputes between siblings because I have seen, I could probably write a book on the number of things that I've seen where everybody says, well, my family would never. Okay. It's kind of like, we hear something one time and it says the last thing that Jim ever said was, "Hey y'all, hold my beer and watch this." You know, well, that kind of goes into the my family would never. They're kind of the same thing, because what happens is money and that it becomes personal, and that's when things can come up. I have seen it happen before, so I always encourage people just to make sure that we're covering all of our tracks.
Hi everyone, I'm Cassidy, the second C in CMC Financial. So Dad sometimes gets on a roll with this podcast and might forget to remind you about a few things. 1, don't forget to like and share this podcast and leave a review. 2, follow CMC Financial on all of the socials, Facebook, Instagram, and LinkedIn. And 3, go check out the website at cmcfp.com. Okay, back to my dad. He's probably still talking.
We lived through it when my grandmother passed away, my mom's
Okay.
mom.
Okay. So you could be a chapter in my book then.
Yeah, what you just described, I lived it. So
Yeah.
it's crazy.
Yeah, it's absolutely nuts. At some point offline, I'll tell you about the most interesting one ever, but it was, quite
Okay.
interesting. Here's the thing, too, is we talk about, your mom passing away and then things going to her 4 children. Okay. But what happens if one of the 4 of you passed away? That's where we have this thing called contingent beneficiaries that come into play.
Right.
And there's a word that it's a Latin phrase called per stirpes. And it's very important that if you have that type of a designation, that we understand what that means. Okay. So per stirpes simply means it stays in the lineage. And so I know you and your wife don't have children. Okay. So, but do some of your siblings have children? You have nieces and nephews.
Yeah, I have a number of nieces and nephews.
Okay. So the question to your mom when she's creating all of this document would be, Mom, if something happened to, what's one of your siblings' name?
To Rob.
To Rob. Okay. Mom, if something happened to Rob prior to or at the same time something happened to you, would you want his portion to go to the other 3 siblings or stay in his lineage to his children? Okay. So if on her document it says in her TOD or her beneficiary designation, and it says the 4 of you per stirpes, what that means is their portion will stay in their lineage. If you don't have that designation and you don't have a contingent beneficiary, then what would happen in that scenario is Rob's portion would go to the other 3 of you. Okay.
I believe that's the way we have it set up.
Okay. And that's perfectly fine. Okay. A lot of times someone has the intent of making sure that it stays, and they say, well, my kids would always make sure that, and then ...
Right.
I've heard that one before too.
Yes.
And so, these are all things that we want to watch. I'll give you one final scenario before I kind of wrap up this episode. This was my client last week. Okay. We have a married individual, but is an only child. Okay. Dad put her on his investment account. Okay. That he inherited from his father when he passed away in the early 90s. This is where cost basis comes in. Okay.
Mm-hmm.
So we have an investment, let's call it 300,000 is the value today. Okay. And let's say that when he inherited it, it was worth 100,000. Okay. Kept the same investments is very common, and this happens. Okay. So dad inherits this investment at $100,000. That's his cost basis. If he makes a sale at any point while he's alive, he's potentially going to have a capital gain. If he does that today and he gets the 300, he would have a capital gain of $200,000 that he would pay capital gains tax on. Okay.
Yep.
What he did earlier this year is he added his daughter to that account. Okay. So two things happened. Number one is he made an irrevocable gift to his daughter. You're allowed to distribute $19,000 per year with no gift tax ramifications and no gift tax form filed. Because one half it was 150,000, it was greater than 19, he would be required to pay a gift tax form. No, there's no tax due, but required to file a gift tax form in the year that he makes the gift. Okay. But more importantly, here's what happens. His intent is for his daughter to inherit the 300,000, and then maybe she diversify that fund when she receives it. Okay. The problem is if she inherits it as a owner, she was gifted one half. So now her basis is 150,000. Okay. And then she inherits the other half at, let's say, 300,000, but her total basis is not 300,000. One half of it was at his original 100,000, so one half is 50, and one half of it is at the stepped up amount, which was 300. Half of that is 150. So you take the 50 and the 150, her basis is now 200,000. What he did is she inherited a capital gain of $100,000 taxable in gain at the state that we're in plus federal as 20%. So he just created a $20,000 tax bill to her if she inherits that money. A better way to do it would be to have it in just his name. She has power of attorney. Okay, so she can do everything while he's alive. She inherits it through transfer on death, through TOD. Then she gets the complete step up in basis. She sells it the next day to diversify. Now she has no capital gain.
Right.
So as we went through that scenario, she looked at me. She said, so basically you just saved me $20,000 in tax. And I said, potentially. And she said, well, thank you very much. We'll do it your way. And so it all goes back to the original question of, should I be on mom's checking account? You could take checking account. You could say investment account. You could say house. You could say land. You could say other assets. You could say whatever you wanted and insert it in that spot. And I'm going to go back to my very first statement. The answer may be yes. But the answer may also be no, but here are some potential solutions to take care of those challenges as you go through. So this is a topic that I wanted to discuss on the podcast. I get it all the time. It's not as black and white as everything, but there's some things that you have to think through. And so what I would say is if anybody has questions about this, reach out to us, reach out to your advisors that know your entire situation, to see. So, RJ, any final thoughts or questions from you?
No, I mean, what you described, we're basically living through. And I think communication, especially when you have siblings involved, there's four of us. Mm-hmm. I do have to say the four of us communicate on a regular basis. And at this point in time, I am positive to say that we are all on the same page.
Well, that's great. I'm glad to hear. And you know what? Most families are, but not all.
Yeah. Well, an in-law can throw a wrench into situations. We've seen that.
Yeah.
Like I said, with my grandmother on my mom's side, that was just a nightmare, and we lived through it, and it was terrible. And my mom had to deal with a really ugly situation, and it split the family.
Yeah.
So So communication for me, my advice to people: Communicate, communicate, communicate. Make sure everyone knows exactly what's going on.
I will 100% agree with that. In the next episode, we're going to have a guest and we're going to talk about a family meeting and we're going to talk about legacy planning. So this sort of is going to dovetail into the next episode on the podcast because it talks about a lot of the things that we've discussed around communication. And, as an advisor, that's something I'm always looking at. So, RJ, I know we always end with, kind of contact information. If somebody has questions about this topic or any other, they can reach us. My direct number is 205-510-9074. Call or text. You can email me, find us on social media, CMC Financial on YouTube, Facebook, Instagram, and LinkedIn.
Sounds good, Jim. And thank you for listening to the Financial Puzzle Playbook podcast. We ask you to share this podcast, rate it, and leave a review because this actually helps others find the show. Again, thank you for listening. And for Jim and everyone at the Financial Puzzle Playbook, I'm RJ Malik, and we'll see you at the next podcast.